Ram Ramji, welcome to Legal Lens. In this video, we will discuss a landmark judgment wherein we will first talk about facts of a case, issue involved in the case, arguments from both the sides, and lastly, decision with reason. This video will be useful for the students preparing for Judiciary as well as Clat, and also for advocates preparing for AOR examination. So please do like, share, and subscribe my channel. Case title is Githa Hariharan and Another versus Reserve Bank of India and Another. In this case, the constitutional validity of Section 6A of the Hindu Minority and Guardianship Act 1956, which is called as HMGA, and Section 19B of the Guardians and Wards Act 1890 was challenged. The petitioner argued that these provisions discriminate against women by relegating the mother to an inferior position as natural guardian of her minor child during the lifetime of the father. So in this case, the facts is that Githa Hariharan, a well-known author and mother of a minor son Ravi, she applied to RBI under RBI relief bond scheme, wherein she wanted to invest in the name of her minor son. Thereby she applied as a natural guardian of the child. However, the RBI rejected her application and said that she is not a natural guardian under law, since the father of a minor is was alive that time, and so he is the natural guardian, and RBI rejected this. By the RBI supported their arguments on the basis of Section 6 Clause A of HMGA, which says that the natural guardian of a Hindu minor in respect of his minor's person as well as in respect to minor's property is father, and after him the mother. So here the RBI has interpreted after him means after the death of, if you will give a plain reading to it, it means that after death of the father, once he is not alive, after him the mother will be natural guardian. So in this case, at that time she wanted to invest in RBI relief bond. His father was minor child's father was alive, and therefore the RBI rejected his application. Thereafter, as here it is written, the phrase after him was interpreted to mean after the father's death. So thereby the RBI rejected her application. Thereby the issues were whether Section 6A of HMAGA Act 1956 violates Article 14 and 15 of the Constitution by discriminating on the basis of sex. Question issue number 2 is whether the mother can act as a natural guardian of her minor child during the lifetime of the father, especially when the father is unwilling or unable to act. Now what the argument was contended by the petitioner, that is Githa Hariharan. The first, he said, so in this case the Githa Hariharan and his husband both were one side, so husband was not having any problem, but since there is a law and therefore the respondent, that is the RBI, was having problem in this case. So firstly they submitted on the basis of gender discrimination. They say the submission of the petitioners were that the expression after him was discriminatory and unconstitutional, as it violates Article 14 on the basis of equality, and 15 which says that there should be no discrimination on the basis of sex. So for being a woman there should be no discrimination in any law. They also contended that this provision has placed the mother in a secondary position even when she was otherwise fully capable. So this was the contention of the petition on the basis of gender discrimination. Now secondly, they contended the best interest of the child. They said that the child's welfare is the paramount importance. When you will read HMGA in section 13, it provides the best interest of the child is seen. So in that, what is saying that the child welfare is the paramount importance, and law should not be mechanically prioritize the father So when see, basically we see the what is the interest of the child, whether the interest of the child like if he is staying with his mother, so it will be more served, his interest will be more served and protected, or if he is staying with his father it will be. So the mainly in these provisions, in mainly these acts, the court sees the child's welfare is of paramount importance. Now thirdly, the see content of the basic living constitution. So law is very dynamic, and it is one of the principle of jurisprudence also, that since law is dynamic, and so it needs to be changed according to the society changes and realities. And also they supported their arguments on the basis of constitutional morality, and they said that interpretation should evolve with the change of society and constitutional morality, and not in a rigid patriarchy like in patriarchy form earlier it was. So it should not be interpreted in such way. Their contention was this. Now the fourth submission, they said that there is equal parenting. The petitioner said that the father and mother had equal capabilities, and any distinction based solely on the sex was arbitrary. So they were telling that father and mother are giving equal paternity, so it should not be discrimination only on the basis of sex, because she is women, so she cannot be a natural guardian. Now what is the argument by the respondent, that is RBI and Union of India? So what the RBI said, that they based their submission on the basis of literal interpretation of law. So the RBI defended its action by relying that if you give a plain reading of section 6A, which uses the phrase after him. So once if a layman reads it, see, if you see after this judgment, after him is read differently, but earlier it was read that after him, after the death of the father. So the in the same way the RBI has also contended, he also submitted in the same way, that if you give a later interpretation, the conduct, what they did, the act, what they did, it is supported by that only. Now secondly, what is the legislative intent? They said that HMGA reflects legislative will, or if any changes is required, it should be changed by the amendment of the legislature, and there should not be a judicial interpretation. Thirdly, they said there is no absolute denial. They are saying the mother could become a guardian after the father, but not when the father is alive. They are saying that she can become a natural guardian, but once the father is no more, thereafter only she can become. Now what is the judgment of Honorable Supreme Court? The Supreme Court ruled in the favor of the petitioner, that is Githa Hariharan, and read down the expression after him in section 6A to mean in absence of, or in father is unwilling or unable to act as a guardian. Now in the absence of, like he is not found, yeah, he is not willing to keep his children, okay, as well as his mother, or he's unable to act as a guardian, like he is not having sufficient means to provide proper schooling, fooding to his child. In such condition, after him should be read not as a after death of the father, but it should be read as in the absence, or in the case of unwilling or unable to act as a guardian. Now what are the key holdings? The court based their judgment on the progressive interpretation of after him. The court held that after him does not mean after his father's death, but also includes situations where the father is not capable, is not willing, or absent in discharge of guardianship duties. Secondly, the court said the mother and father equally natural guardians. The mother can act as a natural guardian even during the lifetime of the father, under appropriate circumstances. So the court is saying that mother and father both are equal natural guardian, but she can act as a natural guardian even during the lifetime of the father, but appropriate circumstances, जो जैसे कि मैंने बताया कि that he is unwilling, or he is not even capable, or he is absent. So in such circumstances, the mother will be considered as a natural guardian. The thirdly, the court said that the constitutional values prevails. The court said there is something written in a constitution, and there is some act which is written, like there is a separate provision for that. Now the court stated that जो statutory provision होते हैं must be interpreted in the light of article 14 and 15 and avoid unconstitutional discrimination. मतलब कोई भी provisions है it should be read or interpreted in light of article 14 15. 14 talks about equality and 15 talks about there should not be discrimination, and if you do this it will avoid unconstitutional discrimination. The court relied on this. The court fourthly relied on the child's welfare is supreme. The court said that the child's welfare, the minor's child welfare, is the primary consideration, and it should not be decided on the basis of whether the actual guardian is male or female. So the court, now what is the reasons of reasoning by the court? The court acknowledged that literal interpretation would create gender discrimination, which is contrary to the constitution. The court emphasized that HMGA must be read in a way that advances gender equality and not a rigid patriarchal framework. Very simple, and it is applied the principle of harmonious construction, ensuring that the personal law are read with constitutional guarantees. तो हार्मोनियस कंस्ट्रक्शन कहता है कि कोर्ट एक बैलेंस में निकालता है, एक रास्ता जो कि बीच से निकले. And then this court applied this the principle of harmonious construction and interpreted the word after him, the expression after him. Now, what is the impact of this judgment? This judgment is a landmark victory for gender justice and ensuring that the mother are not a second-class guardian. Promoted a modern, child-centric and equality-based interpretation of personal law. Set a precedent for reading personal laws in conformity with constitutional values, especially gender equality. So now you can read a conclusion wherein the Githa Hariharan vs. IBA is a pioneering case in advancing gender equality in guardianship law. तो आप पढ़ सकते हैं ये. So basically इस जजमेंट में आफ्टर हिम को डिफाइन किया है, जो कि सेक्शन 6A में दे रखा है कि आफ्टर हिम. Earlier it was, if you give a literal interpretation of this expression, so people used to read like after him as after the death of father. Mother is a natural guardian. But if you give the interpretation in the light of child's welfare as well as article 14 15, so the court said in some circumstances where the father is unwilling or is not capable or is absent, like he has gone for some work or he is not staying together, in such circumstances the father or the mother will be considered as a natural guardian, and the father after him will be read as that after absence of the father, or after he is unwilling, or after he is not cooperating, or he is absent, in circumstances after him should be read like this. So there is a interpretation of the expression after him provided in the section 6A. So please do like and subscribe my channel for more such videos, and this particular judgment will help you in both the examination, like in Clat, Judiciary, as well as in AOR examination. Although in AOR examination you need to read the whole judgment, but this judgment will help you somewhere. So thank you. Please do like and subscribe my channel so that I can make more and more videos by motivation. So thank you. Jai Hind, Jai Bharat.